Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Today, me, Nur Shakira binti Dek, and
Azli binti Osman.
we review on the case of R and I Securities Sdn Berhad and Golden Castle Finance Corporation and Berhad. So I will first introduce you to the parties that are involved in this case, which is the first one is the charger, Malaysian Wool Products Berhad. This is Hong Kong Security Limited. This is a third party in this case, in which they has a relation with Malaysian Wool Products Berhad. They have a contract between these two. And the respondent of this case, which is Golden Castle Finance Corporation and Berhad, and the appellant of this case are R&I Securities. So then I will explain to you on the facts of the case. Okay, in the first, this case is about the validity of charge. Malaysian Wool Products Berhad first create the first charge with the respondent, Golden Castle Finance Corporation and Berhad. So in the charge, in their agreement, clause 6 of the agreement stated the prohibition, not the prohibition, condition in which if Malaysian Wool wanted to create subsequent charge, they must get consent from the respondent. Okay, later on, Malaysian Wool products create the second charge with the appellant. So here, the appellant must get consent from the respondent. They do ask for the permission. However, the respondent did not give refused to give consent for them to create the second charge. But the appellant still continued to create the charge. Okay, later on, appellant wanted to enter into a caveat, since this Hong Kong security, which the third party who need to repay the loan, they did not pay the loan. So they wanted to enter into caveat to secure or to protect their interest on that land. So, however, the respondent wanted to remove the caveat, but the appellant sought for the extension of the caveat. But however, in this case, the court held that.
The court held that first. Okay, the court under subsection 241 clause 1 stated that the charge is not even a charge, meaning that the charge made between the charger and the second chargee is not a charge because there is no loan transaction between them. Second, section 241 subsection 3. Okay, in this section state that if they want to create another charge or subsequent charge, they must subject to any prohibition. So in this case, the prohibition stated in clause 6, which
of the
is
agreement.
Of the first charge agreements, if they want to create another charge or subsequent charge, they must get the consent from the first charges. But in this case, they refuse to give the consent. So last but not least, section 326 clause 2. This section is about discretionary power of the court to give for extension of the caveat. In this case, as the appellant sought for extension of the caveat, the court said that is a discretionary power of court. So the court disallowed the application of the appellants. So this is a legal principle. So legal principle in this case is about the validity of the charge. So the creation of a charge where there is no loan transactions is not possible, since defeats the essence of the charge, which is to secure to repayment of the loan and the obligation to repay it. So means that if there is no any loan transaction between the parties, so there is not even a charge between them. So that's all from us. Thank you.
Thank you.